for that, we have to do. Yeah, just hit the little button right there in the lower side. Yeah. Just remember the light's on.
Yeah. I'm here. I've been in CREEDMOOR since 2000. I live in Lake Road. I used to live in Main Street. I live in Lake Road now, 514 Lake Road. I've been a citizen of CREEDMOOR since 2000. I don't know if you I would allow to say that, but I ran for the city for one time and I ran for mayor one time, but that's a long story. But I'm glad I was only privileged to they called me. I think Archie and Georgina and the board, and would you be okay to help the city in any capacity? Oh, I got to work in the hospital. It's okay. And then he said, Dennis. I said, oh, I know you and Darryl Moss, yeah. I see you preach in the church. And then, oh my God, Dennis is an excited guy right there. So I'm here. I'm on the privilege that they appointed me the board, and I came here. I think that was February or something else too, but yeah. So it's me. I'm originally from the Philippines. If you hear my accent a little bit, but I've been here since 1993. I work at the hospital in Batna. I'm a nurse there. So thank you for having me. And get to know Dennis. I see you again.
Good. Well, we're glad to have you. And I mean, serving is what it's really all about. And as you can tell, few people serve.
I know.
And it's difficult. It's difficult because of work and jobs and all the other things. And so I appreciate you volunteering and stepping up. And I hope to tell Archie and Mayor Pro Tem that I appreciate them. Yes. So thank you for serving and glad to have you on board. Is there any other old business that we have? I think that may be it. Hearing none, we'll go to new business. And for some, this, obviously with a new member, this will be the first time that you've heard a case, but for some others, we've gone through a few here and there, so we'll entertain the case on the docket. I think if I recall, so I have my legal support here, I get to kind of run this how I like to.
My recommendation is that you go ahead and gavel us in, open the evidentiary hearing.
Okay.
I believe that the appellant is represented by counsel this evening. I believe that he may have some kind of initial procedural matters or kind of housekeeping items that he'd like to address before we get into the presentation.
Okay.
So that would be my recommendation, to go ahead and open the public hearing. We allow counsel for the appellant to go ahead and kind of make his opening. If he's got an objection, maybe request that for the board, go ahead and hear him out. We can address those issues, and then if the board sees fit, we can move forward.
Okay, sounds good. So I'm going to open the hearing of AP 2024-01, and counsel has the floor.
Yes, sir. Thank you, Mr. Chairman, members of the board. My name is Carl Burnett. I'm a lawyer from Oxford. I've been a lawyer for about 40 years. The law firm at Edmondson and Burnett. And I'm here representing the petitioners, the appellants in this matter. I've got three sort of preliminary items that I'd like to talk about. The first is a motion to continue this hearing. And I would represent to this board, and Mr. Burnett knows this, and I was only retained to represent these folks last Monday. And I had, as soon as that happened, I called Mr. Fredos and requested that the matter be continued because I just really haven't had enough time to digest all of this information. And fine to do that, and then I spoke to Mr. Hornick about that, and he said he could do it, so that I would have to make a motion to the board. Which is what I'm doing first of all, as an initial matter. But I just wanted you to know that I tried to get this done without everybody having to come up here. So that would be my first request, is this be continued to the next regular meeting, which I think is in November, which would give me adequate time to get my information, so that I'll be fully prepared to present this case to the board on behalf of my clients. The second matter is that I've looked at the statute, and I have some questions as to whether or not this board is properly constituted, because I think the law requires that there be 5 members. I don't think there are 5 members that I could find anywhere listed. And I just heard you talk about that there's not a 5th member. I understand that you don't have to have 5 present at the meeting, but I believe that in order for the board to be a properly constituted board, that there has to be 5 members. And then the final point, well, let me go back. This matter is being recorded.
It is.
It's being recorded so that either party can appeal the decision of the board, whatever it is, to the Superior Court in Graham County. And I'm sure we all know that. All of these items are items that I'm making for the record, just so that I include everything that I would potentially object to. The final matter is whether or not there's a conflict of interest between the city attorney who has represented the city some in this matter, and him being the legal advisor to this board, which serves as a finder of fact in the case. And I don't believe that that's proper. I mean, I'm raising that as an issue. I spoke to Mr. Hornack about that before we started. I didn't want to, give him any kind of undue surprise, but I did speak to him about that. But first of all, I would make the motion to continue, and then I guess we'll go from there.
Okay, so let's start with that. We got long arms, it's a little different. I had to remind Mayor that one too. I need to get some feedback from staff about notification originally, it being within the last week, it sounds like, last Monday, and a decision to go ahead with this meeting. I think I have a good feel for that decision, but I'd like to get feedback since that conversation, you had that conversation with legal counsel.
So, Mr. Chairman, I don't really have a microphone on, but I'll stand up and make sure I get into the mic. June 24th, I sent out the violation letter. Roughly 28 days or so after that, Mr. Sexton contacted me regarding the appeal and the window that was open, for appeal being 30 days. Certainly they wanted to get in before that 30 days. I accommodated them, of course, at that time, and they filed a timely application. Based on our previously established schedule, I was able to get this item onto the August agenda. You all received an August agenda packet that was essentially complete with the application and all the other materials, so I was able to put together the record in time. I received a phone call from Mr. Sexton requesting that it be delayed because he felt it was too soon. Right after the appeal, they needed to get a grip on it and handle it appropriately. And I agreed. I said, no problem. It was quick, but I wanted to accommodate you as soon as I could. You know, the ordinance calls for me to act in a steadfast manner, try to get the action to the board as soon as possible so that we can get a resolution. And that was my goal. At their request, I postponed it 30 days to this meeting, September 9th. Put together essentially the same agenda packet, added a few items to it, but y'all got this packet a week ago or so, maybe it was when we sent it out. But then I only received a call from Mr. Burnett. Was it Friday? I'm not sure exactly when he contacted me, and then again today, saying that it was last minute. Well, for me, it wasn't last minute. I've been working on this for over 40 days, you know, maybe more. And had this packet all together. I'm sorry that it's last minute to him, but you know, you held it. The party knew about this matter scheduled for tonight. It's up to you.
No, so just to be clear, you received notice of request from legal counsel for
book here. 1 second. I have
on Friday.
I have a book.
And based on what we just heard, he was retained last Monday, a week ago today. Am I correct?
Yes, sir. That's right. So I had a call from Mr. Burnett at 9:44 a.m. on Friday of last week, and then again today, this afternoon. And that copy, according to my notes. He had left me his telephone number, his cell number, identified himself as the representative of the applicant, and asked, you know, if I could delay.
Okay.
And I said I was ready. You know, for me, it causes more work, causes us all to come together again for another, you know, meeting night, which we might have to anyway, but, you know, my job is done. My work is prepared. The record is before you. For me, to move forward is okay.
Thank you. I'd like to just ask a question or two, and then I'll ask counsel. So you were retained last Monday, a week ago today.
That's right.
And is anyone from your who you're representing, are they here?
Yes, sir. They're all of them are back here.
Okay.
I actually didn't get the entire packet until today. So I didn't know it had been sent out previously.
Okay. Again, I think I know the answers to questions. They say you shouldn't, if you're a lawyer, you shouldn't ask questions that you already know, and I believe I do understand. I can call anyone I'd like to talk to about anything here.
In terms of calling witnesses?
Mm-hmm.
Sure, you can call witnesses.
Mm-hmm.
Absolutely.
And they would need to be sworn in, unless they're even as legal counsel, they really need to be sworn in. I would like to understand better why the delay in retaining you. That makes a difference in my vote for sure, and I think it will make a difference to the members to understand why. You heard that we've kind of gone through this now. It's going on 3 months, and the staff has been more than accommodating, I believe, in trying to give an opportunity for the appeal to be heard and to bring the members together. And I also happen to know that the members have had to make some sacrifices to be here to make sure we gave due consideration to the appeal. So I'm a little concerned that this was delayed to this point. I'd like to understand better why you were only retained in the last week and only notified staff in the last 2 days, because either way it would have caused problems for us. So I want to open the floor to the other members before I try to get any additional information to call for a motion. And I also want to ask legal counsel about the other two items, in that regard. If either one of you have any, questions, thoughts based on what you're hearing about delaying this until our next meeting, which will be November.
For what it's worth, I'll also add, the board would not necessarily need to continue this until your regular November meeting.
Right.
Another option would be for the board to call a special meeting sometime between now and then. If the board can identify and state the time, the date, time, and place of the meeting during an open session of this meeting this evening, there's no additional notice procedure required for city staff to go through. As long as we're not calling a meeting for fewer than 48 hours, which is the time to publish a special meeting notice,
right.
I think that the board could continue this to a future date that is sooner than your next regular meeting, which would be your next quarterly meeting, which would take place in November.
Before I comment, I still want to leave the floor open for anyone else for any comments or statements about it. I did already conclude that we would need to have a special meeting one way or the other anyway. I did not assume that if we heard everything tonight that we would make a decision tonight. We have some time that we usually take between hearing all the evidence and getting all the information we need. I was concluding that we would likely have to have a call meeting for us to review and decide. Delaying it would still put that meeting in there somewhere and perhaps deal with the decision in the November meeting. I'm throwing that out there because we haven't decided, but I at least wanted to put that there. But that said, I want to go straight to legal counsel on this and just ask you a few questions. We've received this. We can review the information associated with this and the laws without it being a hearing per se, and hear all the legal and other evidence associated with it. In other words, the presentation from the appeal, that's public record, and if we want to review that and talk about that, we can.
Certainly. Well, so you are certainly entitled to review the evidentiary record that's been prepared and presented to you outside of the evidentiary hearing. I would encourage you not to engage in independent fact-finding outside of the evidentiary hearing. So you can review what's been presented in the agenda package, and anything that assuming that we were to open the evidentiary hearing this evening, you would hear potentially some evidence from the appellant, possibly also from city staff. You could consider that evidence, that testimony that you might receive this evening outside the evidentiary hearing. You should not discuss that amongst yourselves. You should not speak about this case with city staff or with anybody on behalf of the appellant outside of the evidentiary hearing.
Outside specifically of the evidentiary hearing. Okay. Now, I ask that question because then it allows us to at least review what we've received and not have wasted our time coming up for what will now end up being 3 separate meetings relating to this. So at least it gives an opportunity to get the information. It doesn't allow obviously having some knowledge of what the background is, and I want to be fair in that regard because I understand that it's only been a week for you. I would love to understand it better, but then I concluded it doesn't make any difference for me to understand it better. The question is, do we have an opportunity to be able to understand what we have? Now, I've reviewed it. and I hope the other members had an opportunity to review, but that review also comes with questions about what we're seeing and the why of it. And some of the writing I didn't quite, wasn't clear enough for me to be able to do that analysis. I would end up asking that question during the hearing. So that's why I'm bringing this up. So this is the decision at hand. But I do want to ask you another question, because I think this affects, since it's already been brought up, this affects whether we should have a hearing period.
You'd like to discuss the other two items?
Yeah, I definitely want to discuss number two, which I believe, again, I understand because we've gone through this already before, that it's what constitutes a quorum. And it's not that it's required for us to have 5 members. It's the members we have. If I recall, there's no minimum number of members. It may be, but there's a quorum associated with it. And as long as we have a quorum, we're able to hold meetings and we're able to make decisions. Is my understanding correct about that?
So here's what I would recommend. I think before we discuss either or both of points 2 and 3, I think that we should hold a closed session where just the board and I can discuss this for the purposes of providing advice to the board under North Carolina General Statutes, Chapter 143, Section 318.11A3. That's a statute that specifically allows us to hold a closed session where the attorney retained to advise the board to provide attorney-client privilege advice.
Okay.
I think that a substantive discussion of those two issues probably falls into that.
So you are recommending that, because officially the evidentiary hearing is open, because I opened it. So you are recommending that I close it and that I go into closed session for us to discuss 2 and 3 and its relevance to 1.
That's correct. And then we would return to open session, we would call the audience back in, and then this board could discuss whether or not to grant the continuance, and assuming that the consensus appears to be to grant the continuance, we discuss how we want to go about doing that, whether that's just rescheduling for your standing November quarterly meeting, or whether that's rescheduling for sometime sooner between now and or however else you want.
However else we can decide to deal with it. Well, I'd like to see if the board would like to get this information that we need in making a decision. We could make the decision without that information. We don't have to have it. But I think it's prudent for us to understand all of what council has provided so that we're making an informed decision. So I'll entertain a motion to close evidentiary and go into closed session.
For the record, that statute that I mentioned, we should specifically mention in the motion, and that is, so if somebody's planning on making a motion, I will read out that statute for you. It's Chapter 143, Section 318.11, subsection A, subparagraph 3. And that's for the purposes of maintaining attorney-client privilege.
Okay.
Mr. Chairman, we're not objecting to that. I'm the lawyer for the city of Oxford, and I know exactly what he's talking about, and we don't have any objection to that.
Okay. But I need to entertain a motion from us, one of us, and a second from us, and a vote to be able to close evidentiary, and then for us to go into closed session.
We'll attempt to make that motion.
Okay.
For what it's worth, now that we've read all that out, and hopefully it'll be very clear in the minutes and the record, and it's clear to everybody in this room, I think that it would be fair for you to just, I move that we go into closed session for the purposes specified in the statute. We just avoid all the reading.
I would make a motion that we close the evidentiary portion of the meeting and go into a closed session to discuss this Chapter 143, Section 318.11, subsection A, subparagraph 3.
Could I get a second?
I second that motion.
Motion's been made and properly seconded that we close the evidentiary and go into closed session, to review some of the other items that council has brought forward. All in favor, please, indicate so by saying aye.
Aye.
Oh,
There's a recording,
Yeah.
and should it stay on?
We'll turn it off, and I'll prepare minutes of the closed session discussion.
okay. All in favor?
Aye.
All opposed? Ayes have it, motion carried. We're going into closed session.